Is this a question of constitutional reality running into conflict with political reality?
Well, often court decisions have political consequences, and I don't think the court should shrink from doing what John Marshall, the first Chief Justice, said was their duty, would declare what the law is, because it will have political consequences, even political consequences that they don't like.
Okay, well, when we consider the actual law here in the 14th Amendment, which says that no one can hold public office, paraphrasing here, of course, if they have engaged in insurrection or rebellion, it seems like a lot of these definitions are frankly quite loose. And especially considering the former president hasn't even actually been charged with insurrection formally, are you worried about the precedent that may be set here, how this could potentially be used against other individuals in the future if this is allowed to stand?
Well, I think the key factor is that there was a 5-day trial in Colorado, and the court took testimony, did rely heavily on the report of the January 6th Commission. Mostly the evidence consisted of statements Trump made or statements which were undisputed, and Trump had a chance to testify at the trial. He did not. He testified in New York, but he didn't testify in Colorado. And the court made findings of fact. And the standard of evidence of proof was clear and convincing evidence. That's pretty rigorous. And the judge made findings that he'd engaged in insurrection. And I don't think up until recently, after the ruling, that Trump ever, or his lawyers ever contested the fact that there was an insurrection and that Trump engaged in it. After all, it was 3.5 hours when he was watching the whole thing on television and not doing a blessed thing.
Well, Jim, I spoke with former Assistant U.S. Attorney and Watergate prosecutor Nick Ackerman yesterday here on Balance of Power, and he seemed largely to agree with you, but I'd like you to take a listen, if you will, to what he told me.
The fact that he's appointed 3 of those justices shouldn't be given a lot of weight. Number one, the same thing happened in Watergate. We had 3 justices appointed by Richard Nixon, yet it was a unanimous decision ordering him to turn over the tapes. 2, if you look at just the conservative philosophy here of reading the text of the amendment, of the 14th Amendment, it's pretty straightforward. If these justices are really strict constructionists, they really have no place to go.
And when we think about these justices, not only were 3 of them appointed by the former president, one of them in particular, Clarence Thomas, is facing calls for recusal from this case, as well as others related to the former president in efforts to overturn the 2020 election because of his wife, Ginny Thomas. How should we be thinking about the justices as individual characters here and what difference this makes, not just in the Colorado and the 14th Amendment case, but also in the case Jack Smith has asked the court to weigh in on in terms of presidential immunity?
Well, the most fun that a lawyer who practices before the Supreme Court or follows the Supreme Court, or a journalist following the Supreme Court, can have is trying to psychoanalyze the justices. As Nick points out, they very often go against the views of the president who appoints them. Probably in ideological issues like abortion or school prayer or most recently college tuition, the justices follow the political views of the president who appointed them. But I think when it comes to a question of law like this, and the history is where there have been questions of law involving Trump, they follow the law. And unless they're totally dishonest intellectually, they will apply the rigorous textual analysis for which they've become so, to which they become so attracted. And if you use a textual analysis, you have to conclude that Trump has to be disqualified under Section 3 of the 14th Amendment.
And finally, I want to ask you one other question, not about the former president, but about someone who worked very close to him in these efforts to overturn the results of the 2020 election. Rudy Giuliani, the former mayor of New York, who just days ago was ordered to pay $148 million to two Georgia poll workers for essentially defaming them, today has filed for bankruptcy. We're talking debts of as much as $500 million with assets of up to $10 million. Does this absolve him from having to make those payments to those poll workers?
Well, the $10 million, if he has it, going to have to go for administration expenses, legal fees, and will be prorated among his creditors. But the interesting thing is, once that happens, he'll be discharged from bankruptcy. But this judgment for $148 million is not dischargeable in bankruptcy because defamation is an intentional tort. And under the bankruptcy law, intentional torts are not dischargeable. So for the rest of his life, he's going to have this judgment hanging over his head for whatever portion of the judgment is unsatisfied. And he's going to have to deal with that.